Good afternoon, evening, morning, whenever it is. Good morning, Vietnam. Hello there to StreamYard, to Dustin, Born Free Films, Born Free Films. What a bad memory. John, Market Watcher, Jack, Gator Boy, excuse me, Frank, Renee, Care, Matthew, Lee, Ben, Rondell, or Rondell, or Rondell. I don't know how to say that exactly correctly. I hope you're all good. So today we're going to do another episode of GTII. This is kind of funny to me because you're almost seeing it in real time. Probably a very unusual view, honestly, because how often you get kind of hear kind of the inner legal side when you're not involved directly in the case, and you hear it kind of at least hopefully explained coherently. I can't guarantee that. And you hear it kind of when it's happening, not like 6 months after the fact. So it's kind of a fun for me too to expose that to everybody so they kind of hear it. And but anyway, obviously the goal is to get this stupid stock trading and everybody to make zillions of dollars and for the deal to close, etc. And that's kind of the underlying thing. So, I've been critical of the receiver and the receivers counsel, but I want to give them credit where credit's due. And part of that is that, and part of that, of course, is going to explain a little bit otherwise. Before we start, of course, and I notice like some people watch this for these terrible jokes. They stay for like 5 seconds and then they split. And I've been threatening this. And what I think I'm going to do is I'm going to start putting some jokes at the very end. So I'm going to kind of split them up. But for today, you're still salvaged. You're safe. And you get what you get. So what happened when the man sued his hotel for losing his luggage? Unfortunately, he lost his case. What's the difference between a lawyer and a boxing referee? A boxing referee doesn't get paid more for a longer fight. Some of these are relevant, or the subject matter might be relevant to what we're experiencing. Why did God invent lawyers? So that used car salesmen would have someone to look down upon. And last but not least, what do you call a lawyer who doesn't chase ambulances? Retired. Not retarded. Retired. Anyway, so we're talking about GTII. I've been kind of like leading you through here, hoping that the deal's going to go forward. And I think John Forrester on his X account, Twitter account, whatever it is, X hasn't stayed. Twitter still exists, but I've seen him make tweets, and he seems pretty optimistic. And in whatever communications I've had with him, he also still remains optimistic up to the current time frame. So I remain optimistic with that. No guarantees of anything. Obviously, it's not legal, financial, or birth advice. It's not even advice about what kind of animals are most common to Northern Africa. It's not advice about anything. Actually, that's what it's advice about, that it's not advice about anything. So that's what you can rely upon. Use it for whatever it's worth. But GTI has been proceeding, and a deal is in negotiations. And at the same time, there's been a bunch of tasks that have been undertaken by the receiver and the receiver's counsel to do, because things had to be done. Part of that is, collecting monies that was owed. Part of that was trying to recapture some shares, and that's been ongoing. I think there was a mediation. As far as I know, to this point in time, I haven't heard anything to say that the mediation was successful. I guess anything's possible, and maybe at some point in time we will hear that, and that might go to part of my other issue, the real issue. But anyway, that's going on, and apparently a bunch of subpoenas were served, and then there was and what happens, this is the cycle, and for whatever reason, I couldn't tell you why. And Ben Palmer, who I saw in there, he kind of threw it out on on a Twitter X. He said, kind of just throwing this out, and thank you, Ben. If I'm sure if the receiver told Hoffman in confidence X, Y, and Z, that Hoffman, of course, would keep that in confidence. And Ben, you hit it right on the nose. So at any point, and I don't quite understand why they've chosen the tact they chose. It's obviously they haven't paid attention, is really the point. Because if they had been paying attention since day one, why wouldn't they want to work with me? And of course, if the receivers council comes to me and says, here's X, Y, and Z, for this reason, and of course, if he tells me I'm going to screw shareholders, that wouldn't be a valid reason. But if he gives me any reason, says just don't disclose it until we disclose it, of course, that's what I'm going to do. No question. And I've offered that many times. And by the way, I offered as of today. So if the receivers council wants to make nice, notwithstanding wherever we are today, I mean, I think it's still more productive if we can work together and I can kind of see what's going on as opposed to be having to guess and call you out about everything, which isn't fun and is not super productive. I'd much rather be working alongside of you. You can keep whatever you need to be confidential, but so that we're not in the dark as to what you do. An example, for example, is what this whole live stream's about. So the way it's gone is something doesn't happen. I call it out. Something is done. There's usually some defect in it, no communication. Then I call them out again, and that's been the cycle. And that's what happened here. So, and it's still going, by the way, still going as of today. So I would request receivers council, notwithstanding whatever hard feelings you have towards me, I will drop mine also. And if you want to have a cordial relationship, I will be happy to, as long as you keep us knowledgeable, at least in a general sense, so we don't have to guess as to what you're doing. And even today, I'm going to point it out to you. I'm going to give you the example why I'm going to say it again. But if you want to work in that manner, I will guarantee you. What are you gonna? I'll give you a hammer. You can hit me in the head if I don't keep my promise here. If you tell me something in confidence and say I can't disclose it for a period of time, I won't. What? It's not going to be hard. What do you mean? If I do, you'll have evidence to say it. Of course, I won't. I don't understand your logic, but anyway, that's old. So going forward, Mr. Receiver and Mr. Receiver's Council, if you want to have a cordial relationship, but I think benefits everybody, I'm throwing myself out there. Okay. So that's where I'm going to start. And again, I also appreciate the fact that you tried to explain the $20,000. So let me get this. And this is kind of like where we started today and why I decided to do a live stream. So at some point in time, and again, very nice people out there, I have to say out there, the shareholders who reach out to me, who have all kinds of things that they tell me, and very nice people. So I'm happy to kind of, converse with the ones I can. Obviously, I can't spend all my time doing it. I've spent quite a bit amount of time, obviously, and I've kind of made you aware of that, of course. But a lot of nice people. So they get communication. So what happens is, at this point in time, the receiver and the Receivers Council won't communicate with me other than if they're obligated. That means I'm still on the service list. So if they're required to serve me with a document, I get the documents. But otherwise, they don't respond to anything I send. Nothing. They just kind of let it go. But they will respond to other people. And usually the response is related basically to a subject that I brought up previously. So it's obviously they're like they're calling Mr. Joe to really answer the question of Mr. Hoffman. That's really the way it's working. And as opposed to having that interaction, they've elected not to do that. So, whatever. Hopefully at some point in time, they'll decide, change that method of communication, because I'm sure I'm not the one. I know this stuff. So I could recognize the ambiguities. If you're not knowledgeable in a lot of this stuff, and there's no fault of your own. It's not your business. Then there's just a lot of stuff you're not going to recognize, and you can be taken. And it's happened, right? We all know it's happened. So let's just bring you up to speed on today. So obviously, my last thing, I harangued about that stipulation to release the 20K, and then John Forster, I think he posted that he didn't have any further information. I think he said on X that he had reached out to the receiver but hadn't received any information. And I don't know if he has received any information to this point in time. I know nobody responded to me, and I made that live stream. That was I think I was pissed. That was on a Friday, and today's Wednesday. So that is, let me count. 7 minus 2, that would be 5. So that's 5 days ago. And today somebody sends me an email. I'm not going to say who sent it to me. And I don't know how many people got this email. So it might have gone out in some form to a bunch of people, because there was a prior email that I read and ripped apart that was sent. And by the way, again, when I rip it apart, I'm not saying, and I repeat this because this is kind of funny. I know it's funny to you. I'm just trying to keep these guys honest. I'm not super trustworthy of them. So I'm scrutinizing everything they do. Doesn't mean that the goal is not going to be met. Those are two separate things. I just want to make sure I don't let anything kind of pass by and be sorry that I let it pass by. And they've elected to communicate in this way, their election. So I have to be, upfront about what I see. And that's where we are. So they responded to somebody about the 20K. And I thought, by the way, I like that. So this is the good part. I'm going to thank the attorneys for the receiver for at least responding about the 20K. Now, again, my biggest complaint, and I'm not going to argue about work product because, again, I don't know, maybe this is going to work out great and it will end fantastic. They will have done a wonderful job, and it's too early for me to tell. When I talk about tactics, I'm talking about tactics, but you don't know till the end because the result might be great. So I'm open to that. But we're not really we haven't got to that. We haven't got to that point. And what happened was there was a release of 20K, and what I did is I read from the stipulation and order. And today, 5 days later, they responded to at least one shareholder. And the shareholder basically was complaining about that 20K. Excuse me for a second. Was wondering about that 20K. And I don't know if his communication was to the receiver or the receiver's counsel or the combination, but I believe the response was back from the receiver's counsel, and I believe the receiver was copied on it, I believe. And again, I don't know how many of these were sent out, because in the prior letter, there was, so that was the one when I said I ripped the prior letter, because there was a bunch of stuff in there that just wasn't well done and didn't make a lot of sense. And that's on the communication side. So this was another letter was sent out. I don't know how many versions of this were sent out. I don't know how many people got out, but it's in response to the 20K. And I wanted to be fair to the receiver and the receiver's counsel by reading it. And then we're going to talk about some of the stuff that's in here. But I have to, again, because I want to be, I try to be fair, honestly. I thank the receiver's counsel for responding and for trying to clarify that 20K that was released. And maybe it's just an ambiguity in the language. Maybe that's something else, but I'll get into the contents. But of course, let me say it a different way. If the receiver's counsel had contacted me on Friday and told me, listen, for X, Y, and Z reasons, the receiver is going to have to release or agree to the release of $20,000. When we probably shareholders, when they find that out, because it's going to be a public record, because per stipulation, they're going to flip. So can you kind of tell them that, calm them down when they see it, to say, after I'm explained what happens, to say, there's some reason and we should kind of let it play out. And knowing what they're doing without disclosing any detail to anyone. And obviously, I can't trade the stock because I can't trade the stock. So that's it. So it's not an issue of insider information being able to trade. If I do trade, I think somebody will watch any trade I make. So I whatever. But anyway, if you would have told me on Friday, listen, there's gonna be money coming out, or there's gonna be a document that's gonna look like money is going out to Reichman, and it's gonna look like it's gonna be used against GTII. So could you tell everybody to calm down, and eventually we're gonna explain it, but there's nothing there. If they would have done that, we could have cut that off in the past, and it would have made everybody feel more comfortable. But for whatever reason, and lawyers are known for this, have terrible communication skills. Sometimes they focus at the task at hand so carefully that they don't communicate with people. And as a result, what they do is they keep on creating ambiguities that don't need to exist. And I think that's part of what's here. That's why I'm always kind of cutting between being critical of what they do, but not cutting off that the deal won't work. I don't want to miss anything. So when I see things, and I'm looking at it pretty carefully, obviously. So if somebody sends me something that they received or sent, or if the receiver sends me something, or there's a document filed, I'm pretty much looking at everything. So they should expect by now that they're going to get some kind of response. So again, I think it would be better if they just reached out and we had a cordial relationship, and they were upfront, and we had a much more discreet relationship. But so be it. Maybe that will happen. So, letter goes out. The letter's in response to the 20K release, and I'm just going to read it because I'm going to be fair. It's coming from counsel for the receiver. At least that's what it says. It's signed by one in particular, and it's the gentleman it's Dylan. So he and I haven't gotten along too well to this point in time, but it's from him. And again, I have to give him props for having responded. So that's good. I think it's a positive thing. Now, I wish again he would have cut this off at the pass beforehand, but so be it. Now I'm going to analyze what he said. So thank you for addressing it. Thank you for referencing how you explain about the 20K. Because let's say the question is, what about this 20K? Why'd you do that? That's in a nutshell. The statements in the below aren't accurate. The $20,000 is not from a GTII account. We actually had a hearing on the account in question months ago, and all disbursements have been reported to the court. This is a personal account of Mr. Reichman where he kept his money. We reached an arrangement in court where we approve his use of the funds in the account, and we do so through a court order. There are no secret transactions. Okay? So that's first paragraph. They're basically saying, this is not from GTII. This is from a Reichman personal account. And we've already kind of agreed to this, and the court, there was some prior order, I guess, and we reached this arrangement, and that there's no secret transactions. And then I go to the stipulation. So this is how the order. So so when I go to my left or your right, I'm going back to the stipulation. Stipulation was filed before the email I'm reading from. So the email came after the stipulation. Stipulation, which released the $20,000, that was before. So the stipulation, so you understand what a stipulation is, that's when both sides agree to something. And then since they agree, they present their agreement to the court, and then the court will sign an order. Unless it's something that's kind of oddball, if the parties both agree, the court will sign the order. Sometimes an order can be submitted and it might be available to everybody. So some other parties might have an opportunity, if they're influenced, to comment on the order. As to this particular stipulation and the order, the first time I saw it was on the 15th of August, and it had already been signed by the court. So when I saw it and it was served on me that way, the court had already signed the order. And so it was done. So there was no way of preparing for that particular transaction. So I don't know if that you would call that not a secret transaction, but it's certainly not a transparent transaction. And if you recall in the prior letter, transparency, and I've pointed out numerous times a lack of transparency. Again, doesn't mean that they can't do a great job. I'm just pointing out defects, and those defects should cause you to have your guard up and to be aware and not just accept what you're told. Doesn't mean you have to think that everybody's out to screw you, but you also shouldn't accept everything at face value. And when someone decides they don't want to interact with you, then you have to call it as you see it, because I don't want to miss something and you guys get screwed. If I'm wrong, that's so be it. These guys can say whatever they want and correct the problem. But if I miss it and you guys get screwed, then I would really, even though I'm not going to feel like I owe anything, obviously. I put my stuff in, but I would really feel really bad if I miss something. That's why as we go through it, I kind of like torture. It's a tortured reading, but we kind of like analyze it and you kind of learn what to look for. It's kind of part of the lesson. So here they're talking about there's no secret agreements, but they did a stipulation and order before anybody got to see it. I would actually call that a secret agreement. I don't know about you. They also referred to, and so here's the confusing part. And again, I wish they would have called me to talk about it. So this email I'm reading from today, by the way, it's today, this morning on August 20th. It is talking about that $20,000. And it says it's not from a GTII account and not secret funds. And then I look at the stipulation. It's not from a GTI account, and that they reached an arrangement and there are no secret transactions. Let me read on. In this case, we vetted where the money was being used, and it's not being used against GTII, as has also been suggested. Okay. Obviously they're watching me. Who could have possibly suggested that the money was, who could have possibly construed that the money might be used against GTII? Who could have possibly come to that conclusion? Just because the stipulation that they agreed to, so they didn't impose it, they agreed to it. Just because the stipulation says, Mr. Reichman shall be permitted to make a one-time withdrawal in the amount of $20,000 from account ending in 885, which are earmarked for and shall be used by Mr. Reichman to forthwith pay a retainer to counsel. I wonder if somebody might get the idea that it was involving GTII, and that it's confusing when you say that. How could you possibly suggest that that anyone could construe it involved GTII? How is it possible? By the way, this is the kind of stuff that pisses me off, because in a call, this would have been like a nothing. Again, I'll leave it at there. So how could possibly anybody think it's about GTII? Now I'm going back to the stipulation. Wasn't done yet with that stipulation. Remember, the stipulation is something that's drafted, agreed to by the parties, not by me or anybody else. But in this case, it would have been David Reichman's counsel and the receiver's counsel, and the receiver, of course. And here's what it says. And I don't know, perhaps you might think that the giving of the funds might involve GTII. So let's read this. Read this together. So you get out your copies. Let's read it together. 1, 2, 3. Whereas Mr. Reichman seeks to access certain funds in the accounts. I think they said they were Reichman's accounts, but here it sounds like it's GTI's accounts, but so be it. To enable him to retain counsel with respect to certain matters related to Global Tech Industries Group, Inc. Huh. So in the letter today, they suggest they're aghast. How could anybody think that these funds could be used against GTII? And without any explanation there or in the stipulation they agreed to, without explaining it, without telling anyone in any specific language, although apparently they're reaching out to individual shareholders and not others, whatever. Perhaps that's great. I think they know that it's going to reach me anyway. So they should just eliminate that counterpoint and just go straight. I would think that's more efficient. And again, I hope in the end, I don't enjoy doing this too much, but I really don't. I have better things to do with my time, and I think you guys have better things to do with your time. And again, I'm just trying to encourage you. Little communication, direct communication really would get rid of a lot of this stuff. So when I saw the letter that said it wasn't, how can anybody, again, I'm going to read the language. So this is today. In this case, we vetted where the money was being used, and it's not being used against GTII, as has also been suggested. I guess they're the ones who suggested it by the stipulation. Maybe they're referring to themselves in the third person. Maybe. I don't think that's really what they're intending. But obviously the stipulation suggests it's related to GTI and it's giving money for him to have a counsel about GTI. Why do we want him to have any power over GTII? So it must be something for his benefit with regard to GTII, I guess. Is he getting sued on behalf of GTII and he needs money to be covered? Is some agency going after and it's deemed to be better for GTII? Is it the IRS going after him and it's deemed better for GTII? Who knows? But by the language in the stipulation, it surely suggests that it relates to GTII in some fashion. And all I can tell, I know people have been told just to wait, and I'm willing to wait. But somebody believing that they sent this today to clarify things, it's absurd. And again, just communicate like a human being and accurately. Don't just put stuff down and keep contradicting what you're putting out there. It's not helpful. And that's separate and apart from the job you're doing on the legal side. Again, one of the biggest defects that attorneys are notorious for is the inability to communicate, really. And you're exhibiting that, and it's not helpful. And it wastes money, it wastes time, wastes energy, including yours and the receivers. Could all be obviated. So we're going to continue, just to be fair, because again, they reached out, and again, I try to be fair. Thank them for reaching out and trying to explain. This is what this is. This is an explanation of why that 20K did what it did. We are not able to disclose further details of the use. However, the determination was made that the use is necessary and appropriate and inures to the benefit of GTII. Okay, I guess, but I guess that would be about GTII. I don't know why they can't disclose it. I would think, I would say if it inures to the exclusive benefit of GTII, then that's fine. If it doesn't, then I would like to know, but that's probably something that they could make a decision about themselves. They have some discretion to make those decisions. That doesn't clarify what the money is. It actually says they're not going to tell you what the use is. However, the determination was made that the use is necessary and appropriate and inures to the benefit of GTII. Listen, if that's the case, then great. But again, that ambiguity could have easily been avoided, and I could have avoided doing like 3 live streams if they just communicated like human beings in a direct fashion. If they wanted to do it confidentially, do it that way. We also negotiated the amount to significantly less than what was proposed. I don't really get that. If it's his money, then why would you be able to restrict the amount if it wasn't his money, why are you letting him spend it? It's very unclear if, again, if this was an attempt to clarify the reason you haven't done it, and I don't understand why you can't. If it's something you can't disclose because you're afraid of the reaction, that would not be an appropriate reason. If it's some other reason, then perhaps. I don't know. I'm just saying that, I appreciate the attempt to explain the 20K, but I've already pointed out inconsistencies between the letter of today and what's in the stipulation, or at least raising questions about what's in and being in consistent. You've indicated that he's using the money. It's apparently for the benefit of, or it's not even that it will benefit, but it will inure to the benefit of GTII, and that you negotiated it down. I think we're entitled to more information unless you think that's going to somehow, if you really believe it's going to somehow kill GTII or kill the deal because it's disclosed, as long as all the parties know, then I understand you not disclosing. If there's some other reason, then I don't. I will leave it up to you to make that decision. At some point in time, it's obviously going to become obvious, and we'll be able to look back at it. But I'm going to accept it, as I said, I'm going to accept it at face value that when we find out about it, we're not going to come back and look at this thing and say, WTF. So I'll assume it. So in sum, this is the last sentence of that paragraph. In sum, the least amount of money necessary from David Reichman's own account for a purpose that would benefit GTII. I don't know. I mean, that's so vague. I'll wait. But, maybe if David Reichman was in better health and he could earn more money, it would benefit GTII. So maybe they're going to send David Reichman on a vacation to improve his health because that will inure to the benefit of GTII. Just kidding. I'm not really serious about that. But that is so vague. You might as well tell me that Mickey Mouse is going to be joining us too. It means nothing. So if you're not going to be, meaningful in your disclosure, and then don't say a bunch of generalizations that are meaningless, which that is. Likewise, there were allegations that this was done after hours on a Friday. No, that what I primarily said was I saw it after 5:00 on a Friday. And when I looked at the document, it said 5:10 p.m. I didn't know who filed it. I'm just saying when it was received and what the timestamp was on it. It certainly wasn't early in the day. Are they saying that they filed it in the morning and it took all day to get it filed? They certainly didn't talk about it with anybody beforehand. So what's the point? That they didn't disclose. Okay, I'll take their position here. Yeah, so let's say instead of 5:00 on a Friday, that they filed it at 4:00, but they didn't disclose it to anybody, and the order had already been entered by the judge. Do I find that argument meaningful? No, I don't. So those kind of the BS arguments to me. That's a time-wasting argument, meaningless nonsense. Again, if you're going to respond, you don't need to respond like that. It's meaningless. You're directing it at me. If you want to watch the entirety, I referred to the timestamp of the document because I literally was preparing an email, and while I was preparing the email that I didn't send till much later, I saw the stipulation, and then I saw the timestamp on the stipulation. I think it said 5:10. That's my recollection. I think 5:10 or 5:16. I don't remember which one. I thought it was 5:10. And even if it was, let's say it was 4:36 or 3:58 or 2:59 or 1:43. The point is you didn't discuss it with anybody. And here you're saying no secret stuff, and that's what you're doing. And if you don't know the difference, that's a problem. Honestly, that is a real problem. If you can't tell, if you're not disclosing, so if you suppress information, that's not secret because you disclose it after the fact when nobody can do anything. That's secret. I'm sorry. Moving on. So going that, so the he complains about the time on Friday, and it's a meaningless argument. The order was filed by the judge, not counsel, as indicated in the email transmitting the order. We do not control the timing, and the stipulation order was actually submitted to the court days earlier. Even better, we were talking. Okay, that's interesting. So even more reason for these guys to have told us. They obviously, it wasn't the last minute, so they had days to think about it. They certainly could have let us know. We were clamoring about all kinds of things. Can you imagine? We were clamoring about all kinds of things, and if they would have told us at the same time, if they would have dropped that order and the order was releasing the funds, we would have jumped out of our screens. So, okay, congratulations. If you presented it earlier and you weren't trying to stuff it at the end, you get a green check mark for that. You get a red check mark for not having disclosed it and talked about it beforehand, so we wouldn't take a little poopy in our pants when we saw it. In response to your inquiry below, GTI funds have not been released to defendants. That is confusing to me. Oh, okay. To the contrary, we successfully defeated a motion from Mr. Reichman for his advancement of his legal costs, which is provided for in the company's bylaws. That is, the shareholders agreed that if the directors and officers were sued by shareholders for certain sums, the company would pay all legal fees. The receiver prevailed in that. So I don't understand the argument when they say that they're releasing $20,000 an account ending 885. That's not GTI's money. If it's not a GTI account, don't you claim, I think this is what the receiver claims in all those various reports, that I think he claims that, if I recall, and you guys correct me if I'm wrong, maybe I'm wrong, I thought the receiver claimed that Mr. Reichman engaged in all kinds of shenanigans with regard to GTII taking all kinds of money. So, I think it might be very easily stated that any monies that he had would be GTII's. So I didn't kind of understand when the reference to not GTI and money in today's letter, I found that confusing in light of what the stipulation they signed said. I'm sure there's an explanation, but it's confusing. And again, for somebody trying to make a communication to a bunch of investors to clarify something, it fails, as do most of their filings, to be honest. If one of their goals is to advise shareholders and keep them apprised in a way that shareholders would understand, they've failed. I gave them, even early on, and it's open, it's still open if you want to come on. I gave an opportunity for the receiver to come on, for the receiver's, I figured the receiver wouldn't come on by himself, the receiver's counsel, they could, happy to have them on if they want to, state their pitch, make people feel better. Happy it stays open. Offered them before, offered them again. And again, this is, the other half. One half is Forster and things sounds like it's moving forward and everybody sounds like they're helping for the deal. And I'm hoping for the best on the audit that I don't know what happened to it, but I'm hoping for the best. And that's going on. So I'm optimistic. On the other side, I hear all kinds of stuff and I point out inconsistencies, and that stuff makes me uncomfortable. And doesn't mean that the good result can't happen, but if the bad results happen, we could see why. That's all. So again, I hope that's the end of this. I don't have to go back to the stip, but you can see how they're inconsistent. One's talking about GTII. One's talking about this is not GTII. One's talking about what it's for, that it's not for. One says involving GTII for legal purposes, suggests it could be used against GTI, is vague. I understand. Maybe there's some agreement they not disclose what it's for, but they're giving them the money. Maybe. There could be a lot of reasons why they decide to do something in the end, if they're deciding to do whatever they're deciding because they think that it will get done, a deal done, and that's their primary motivation, then I'm fine with that. I'm just not sure that's their primary motivation, but it may go positive anyway. So we have to play it out. And in the meantime, I'm just going to kind of watch carefully. That's the end of that response where they clarified where that 20K was going and the reason it was going and what it was going for. I said that facetiously. I would say after reading that email, I have no idea what it's being used for. I don't really know why they didn't object. And I'm sure there's reasons, by the way, but I don't know why. I don't know how it will benefit GTII, but I also expect that at some point in time we'll figure it out and we will be able to determine ourselves if it all made sense. When I point out inconsistencies or what appeared to me to be inconsistencies, it just makes me a little bit more cautious about things. Again, I remain hopeful, but as time goes on, I'll continue to analyze things as we go on. And if, as a group, and I appreciate any comments that people have after the fact, I absolutely do. It's too hard for me to read with my one eye and I bend over like that. That's why I usually don't. When I can see a comment, I do. Hi, Deborah, by the way. Thank you, by the way. When I see comments, I try to, but since I'm blind in the comment eye, I'm the only person, I think, one of the very few people on YouTube that has a blind comment eye, as far as I know. So I feel I'm very special with that. But anyway, as from this point forward, obviously, when I see something that I think is out of line, I'll call it out, and I'll try to put it in perspective for you. So, I do try to paint a parallel channels. One is the deal and getting it trading, and one is how things are being communicated, how things are being handled, my relationship with them. And that's, again, different. And one could be terrible and one could be good, but we better if both were on the same keel, because it would make everybody feel better and would probably cost everybody less money. So I'm going to leave it there. For all you that hung out with us and me and everybody else here, I appreciate everybody who kind of hung out there. Thank you again for hanging out and keeping me company. And I'll keep you apprised of everything that's going on. Be well, take care, have a great day, and